Okay, we're back now with Danielle Austin. She's the victim in this case. She's the victim of CPS and the county prosecutor, Risa Scully, and whoever that other gal was that was part of this case when it first got started. I believe her name was
Stephanie Smith.
No, Sarah Huyser. She was the she's listed as the prosecuting attorney. Stephanie Smith from DHS, Matthew Hagan, and of course yourself, Danielle Austin. And I just wanted to talk to you a little bit about how you were served, or how you were perceived to have been served. And just, here's a copy of the proof of service, and it says here that Wendy Yost personally served you on July 23rd at 2:57 p.m. Do you remember Wendy Yost? I mean, do you remember her serving you?
No.
What do you remember from that?
The only thing I remember is just talking to my so-called court-appointed attorney.
Okay. So before talking to him, you weren't given any paperwork?
No.
Nobody came up to you with this summons and petition and said, Danielle Austin, you were served?
No.
So, okay, do you know what Wendy Yost looks like? I mean, do you know her?
No.
Have you ever seen her before?
No.
So if there was a lineup, you wouldn't be able to pick her out, would you?
No.
Because you don't know what she looks like. But here in this proof of service, she claims to have personally served you at 2:57 p.m. on July 23rd, 2014. How does that make you feel?
Upset? Well, it makes me upset in many different ways, that, my rights were violated. I wasn't given the adequate time to be able to have my own defense, my own attorney, to figure anything out. Everything was just thrown at me. Does
this scare you that this woman that you don't know is claiming to have personally served you?
Yes.
Okay, well, this is kind of the pretext of what we're talking about here is to outline the state of mind of Danielle Austin. This woman is claiming to have served her a copy of the summons and petition, and she didn't. She didn't serve Danielle personally, according to Danielle herself. She only got a copy of the paperwork after the hearing, handed to her by some man calling himself her court-appointed attorney. Now, looking at the proof of service again, it's a requirement in the court rules that you're given this prior to any legal proceedings against you, because it's also a notification of rights. Did you understand that when you were going into this hearing? Was some man calling himself your lawyer?
No.
Okay, were you ever noticed of this warning here, which is, part of the requirement of Michigan State court rules? I'll just read it here real quick. Warning. You are notified that this hearing may result in a temporary or permanent loss of your rights to the children. Did you have that warning before you went into court?
No.
How about, were you noticed of your right to an attorney before going into this hearing?
No.
Were you noticed of your right to an attorney at the hearing?
Yes, they did tell me as they were doing the proceedings.
So it was kind of like, oh, by the way, you have a right to an attorney, and before you got here, we appointed you one.
Basically.
Okay. That sounds pretty convenient for them. I mean, they got all the bugs worked out, right? They just kind of saddled you right up and rode you out of there. How about your right to trial by jury? Did anybody tell you about that?
They did, but again, I didn't know about any of that stuff and didn't know if that would apply to me or what.
Like bugs hitting the windshield, all this stuff. Your kids have already been taken. This man's introduced himself as your court-appointed attorney. He's read through the allegations and he said, "Boy, you're in big trouble here, and you need to just do what?
Just go along. With what they said.
And did that sound right to you at the time?
No, it didn't, and I let him know that. You know, that.
But he said what? It's what you needed to do.
Yeah, pretty much.
Now, did he talk about, you rolling over or doing whatever they needed you or said to do as having a quicker impact on you being able to get your children back, or what was the motivation?
More or less, he said, fighting it wouldn't do really any good.
Fighting it. Defending
you
yourself.
If you just went along, and followed their rules and jumped through their hoops, that you would get your kids back soon.
So that was your motivation for following his advice.
Well, at that time, I didn't see I had any choice, or because I didn't know any different.
And you've never studied law?
No.
So you're not familiar with child protective proceedings?
No.
Have you ever heard of the Michigan court rules before this happened to you?
No.
How about the Michigan Child Protection Act? Have you studied that?
No.
Did you have any need to?
No.
What about jumping through all these hoops they're talking about? Do you feel that you need parenting classes?
No.
Well, it sounds to me like they just want to keep you participating in these proceedings that were initiated arbitrarily against you without notice. And according to the court rules, your continued participation in these proceedings are what keep you trapped in those proceedings.
Right.
Does that sound about right to you?
Mm-hmm.
So tell me what happened at the last hearing.
My last hearing on February 10th?
Yes.
Well, I filed a motion to dismiss my case on the basis of lack of service, proof of service, and...
So you've come to understand to some degree after a period of time that things weren't happening correctly?
Yes.
And you became familiar with what? The Michigan court rules?
Yes.
And the applicable child protection laws?
Right.
Okay, so...
Which is, again, too, the reason why I fired my lawyer, because he wasn't helping me in any way, shape, or form in addressing any of these issues.
So you had conversations with your lawyer prior to this February 10th hearing, and he was unwilling to listen to what you had to say with regard to the notice defects.
Yes, he said it was a waste of time.
A waste of time.
And all I was doing was hurting my case.
Dismissing the case is hurting your case?
Yes.
Okay, so tell me what you did in court. I mean, how did that come about? Did you file a motion? What happened there?
Yes, I filed a motion stating that, my rights were violated, a lack of service, and also that I was representing myself. And so I went to the hearing on February the 10th, and before I could even get started, my lawyer showed up.
The one you
I had
fired?
fired 2 weeks prior, and
started arguing his motion?
Yes, and putting on the record that he thought I was a crazy person, and that,
Everybody's out to get you.
Yeah.
I've heard the recording, so I know what he said, and that's why I'm interjecting a little bit here. But and I found it to be extremely bizarre how Kelly Lambert not only violated you as a client with regard to what he's bound to be, conduct his own business in line with the rules of professional conduct, but it blew me away when he said he'd had multiple conversations with you about your motion, and you'd fired him before you filed your motion, right?
And I never had a conversation with him over my motion.
So he was lying in court. We're going to cut to a break here, and I want you to go into that a little bit more when we come back, because I think it's really important. Okay, we're going to cut to a break. We're back now with Danielle Austin. We're talking about the dirty deeds done to her by her paid attorney, Kelly Lambert. Kelly Lambert was selected out of Grand Rapids because it was some distance from Mount Pleasant, and it was her thought process that she might get a fairer shake by an attorney that wasn't from here. And what we were discussing before the break was the disservice that this paid lawyer did to you. Can you tell me what he did to you in court a little bit?
Well, he just basically tore me to pieces with, you know, a bunch of different things, you know, talking about my motion, that it didn't have any merit, and he had also
any
stated...
legal merit, right?
Yeah, any legal merit, and he, you know, also stated that, you know, he had discussed the motion with me, you know, 3 or 4 times. And that's not true at all. He was never included in this. I never told him about the motion, period. Which, I mean, he contradicted himself because he said he didn't know about the motion.
And then he did, and then you talked about it, and then you had all these discussions about this motion that he didn't know about or didn't know the date. And what about... he also mentioned that you fired him three times or so.
Yeah.
3+ times or what? I forget how he said it, but... didn't you send him an email? And what was in the email?
Well, I sent him an email and told him not to trespass on my case, on my motion that I was fixing to have.
Not to trespass.
Yes.
Trespassing's a pretty serious offense.
And you know, there's so many different ways that he could have gone about doing that. You know,
like a
stipulated withdrawal.
Withdrawal. Okay.
But you know, he didn't. He chose to show up.
And it's funny. The hearing was like 10 minutes in length, and Kelly Lambert argued his motion to be dismissed when he'd already been fired 3+ times to the court, and the fact that him arguing his motion took at least half of the hearing was about his motion to dismiss himself, where he went in and unzealously represented you. I mean, he just bashed you and bashed you and bashed you. I mean, do you feel like you got your money's worth with Kelly Lambert?
No, I don't at all.
And you demanded a refund, didn't you?
Yes, I did.
Has he ever answered you?
Nope.
You also demanded the case file, did you not?
Yep.
And
I
have
never
you gotten...
received that either.
You what?
I never received that either.
So he never sent you anything?
Nope.
He didn't refund any money, and he didn't send you the case file? Okay, well, in the hearing, he says that you faxed him.
No.
Have you ever faxed him?
No.
So, you know, I'm left to believe, thinking that the county probably faxed him and said, you need to get your butt to court here because we need to talk about Daniel's motion not having any legal merit. And that's exactly what happened, right? In the hearing, I was there. A bunch of your friends were there. Kelly Lambert...
It's hard to believe that a lawyer can get a notification at 5:30 in the evening, as he put it, and
by
have
fax.
time. Yeah, by fax.
You
and
never
miraculously can show up the next morning.
Clearing a schedule.
Yeah, doing all of that.
To be in court to zealously represent you. Did you feel zealously represented?
No, not at all.
So, who do you think faxed him?
I think that the county did fax him. It wasn't me.
Well, it was clear to Kelly Lambert that somebody faxed him, notifying him of the hearing the next day, and then probably demanding that he come in, argue a motion to be dismissed, and disparage you at the same time. After Lambert was excused, Attorney Kelly Lambert out of Grand Rapids was excused by the judge. What did the judge say after that, Judge Mark Duthie, with regard to any legal merit?
He said it was nonsensical, that it didn't make sense.
One more time.
Nonsensical. It just doesn't make sense.
And that your motion lacked legal merit.
Yes.
Which is what Kelly Lambert had to say about his client's motion. So at this motion hearing that you filed, asking the court to dismiss your case because you were not properly noticed of it, did anybody make any arguments to the contrary?
No. It was not discussed or brought up. There was other things that were brought up that it had nothing to do with my motion.
So your motion was to dismiss based on the fact you were never served you were never served a copy of the summons and petition, and nobody argued against your motion.
No.
That's very interesting, because there was a lot of discussion. I was there. It was weird. It was kind of crazy. So Judge Duthie says your motion lacked legal merit, and he ultimately denied it, right?
Mm-hmm.
Well, what's the first thing you said when you started representing yourself? Didn't you ask him?
I asked the judge if he was operating under his oath and bond.
And what did he say to that?
Well, at first he didn't hear me, and I had to repeat it again, and then he pointed his finger at me and said, "You are not going to ask me questions."
Well, I think that was kind of strange. You know, judges don't operate at all if they're not operating under their oath and bond. So a refusal to answer that question kind of struck me as really being odd. And talk about a little bit after he allowed you to present your motion and nobody argued against it. And talk about what he said about the next time you come to court or whatever.
Well, he felt that I couldn't represent myself, that I could properly represent myself. So what he had to say was that he was going to present another court-appointed attorney for me, and that he was going to give me the option of whether I would allow it or not, but that nevertheless someone would still be sitting with me and helping me if I needed it.
Basically, you cannot proceed without somebody sitting next to you that isn't under the control of the judge and the prosecutor.
Yes.
Somebody that they can manipulate, somebody that they'll have on their side sitting with you.
Right.
Just like with Kelly Lambert interjecting on the record that your motion had no merit, had no legal merit. And do you feel that it's a continuation of that? You know, the same premise? Having somebody that they can control sitting next to you?
Yes, which is, I don't want one. I want to be able to represent myself. I don't want them to be present with me.
And didn't you get a call yesterday from somebody?
I did. I got a call from another court-appointed attorney who said that he was ordered
by the court to represent you,
represent
right?
me, and I said I did not request.
And didn't you read him the court rule?
Yes, I did read in the court rule.
All right, we're going to cut to another quick break here, and we're going to talk about Danielle's conversation she had just yesterday with some new court-appointed attorney ordered by Judge Mark Duthie, and how that came about. So we'll be right back with you after the break. Okay, we're back, and Danielle Austin has some more to talk about the phone call she received yesterday from Blowham. What's his first name? Another attorney out of Mount Pleasant, Michigan, who's apparently been assigned by Mark Duthie as court-appointed attorney for Danielle Austin in this case that they're continuing to take forward, even though the case does not exist. Talk about that for a second, and go ahead.
Well, they had called me up to let me know that they had another court-appointed attorney for me, and I told them, I said, I didn't ask for a court-appointed attorney, and they said, no, the courts had appointed one for you. And I said, well, I understand that, but according to Rule 3.915, I must request an attorney, or I'm dirt poor to have, a court-appointed attorney, and neither one of those were factors in my...
Let me stop you right there. I'll just read this court rule for you. It's Rule 3.915, Assistance of Attorney. Section B, Child Protective Proceedings, Subsection 1, Respondent, which Daniel's a respondent, and then subsection B again. So it's 3.915B1B, and it's appointment of an attorney. The court shall appoint an attorney to represent the respondent at any hearing, including the preliminary hearing conducted pursuant to these rules, if the respondent requests appointment of attorney. So, did you request the appointment of an attorney?
No, I didn't.
So, the court's handling this for you. That's kind of convenient, right? Again. Well, that's another extremely valid point. Did you request an attorney?
No.
Did you request an attorney at the onset of these proceedings, alleged proceedings against you, when Tony Moses had introduced himself to you as your court-appointed attorney?
No.
Had you requested him?
No.
Had you requested anybody?
No.
So you were never asked, if you wanted a court-appointed attorney, were you?
Right.
So preliminarily, the court assigned you an attorney without your request. Okay, and now you've gone through two lawyers. You had Tony Moses followed by Kelly Lambert, and you fired them both. Mm-hmm. Kelly Lambert, you had to fire him 3 times to get the word get through to him, and you presented your motion in court, and nobody countered your motion. Nobody made argument against your motion to dismiss the case, but your motion was denied. And during those proceedings, I heard Judge Mark Duthie, tell you that he was not going to let you proceed in court without somebody sitting next to you as your court-appointed attorney.
Yes, that's correct.
Just so the audience knows, with a court-appointed attorney, whether he's jumping up and down representing Daniel Austin zealously or not, having a court-appointed attorney sitting at the same bench basically means that everything that's coming from Daniel herself has no meaning to the court. Okay? When you have a court-appointed attorney, you can't freely address the court. This is very important for everybody in this scenario to understand. If you have a court-appointed attorney, even if he's in the bathroom and you're in court by yourself, you cannot speak on your own behalf because you are represented by the attorney whether he's there or not. And I think that's huge, because the court doesn't want to have people like you that have figured out the laws as they pertain to your case in there beating them up, because it really makes them look silly when you've had 8 months exposure to these laws, and they've been doing it as a craft, as a business, many of them for 20 years. So anyways, that's a very important part of this, and in moving forward, it needs to be known and recognized that you've never requested the appointment of an attorney, and that you want everybody to recognize that this is being forced upon you.
Yes, it is being forced upon me, and it was quite aggravating to have that phone conversation, and he somewhat have apologized, and said that, he was just following orders, and that it was already, set in place for him to represent me, and that, and, telling me that he had the court transcript. And I said, well, yeah, I have the court transcript too. I know what I said. I know what Judge Mark Duthie said as well. I said, but nowhere in there did I ever request. I said the judge took it upon himself to appoint one for me.
So he's commanding another court-appointed attorney directly to be with you.
Yes.
That doesn't really sound fair.
Well, it's not fair, and I have the right to defend myself if I want to. I mean,
what gives you that right?
Well, Article 1, Section 13 of the Michigan Constitution says that a suitor in any court of the state has the right to prosecute or defend his suit.
There you have it.
In his own person or as an attorney.
Wow.
Or with an attorney.
Well, you're certainly grasping what's going on here, and that's amazing. And that's what folks in Michigan and all over this country need to start doing. learning law is not difficult if you stick to what your particular case or your needs about. And like Danielle here, you can grab hold of these things and absorb them, because it has real significance to you, because your children are in the balance. And with that, I want to thank you for finding the courage. I can't even fathom what you've been through. It's beyond my comprehension. In light of what I've learned and what I've read, to try and put myself into your shoes, I can't even do it. I don't know how you've maintained it. It's amazing to me, the level of courage you've shown. Because watching these people do these criminal things to you is hugely disparaging to me. And I applaud you. I applaud your effort and your diligence. And with that, we'll cut to a break, and we'll be back shortly. And I want to get my contact information out, and we'll do that right after the break.
Well, welcome back. I guess you've got the gist of this story here, and as we finish up at least this part of this story, because this is going to be ongoing for a while. Once you're in the snares of the court, it's sometimes difficult to get out of it without them trying to pull teeth. So I'd like to just kind of recap the fact that we have a couple of judges involved here. First one's name...
William T. Irvin. He's the one that signed the summons on the same day requesting 4 people to show up in court that day.
Right. Knowing that he was in violation of the Michigan court rule. Correct. By doing so. Okay, so he's kind of set this whole scenario up. Then, on the same day, she shows up to court with another judge. Is that correct? Because there was another...
Actually, I believe the hearing was heard by the referee. It's kind of unclear. In the latest hearing, Mark Duthie claims he'd never had any participation in this case, but he is another judge, Mark Duthie. In the February 10th hearing, claimed that the February 10th hearing was his first participation in the case. Here's the transcript right here. He says, "This is the first time I've been involved with this case."
And this was on what date?
Which is total BS. On February 10th.
February 10th. And we know for a fact that he signed on July 23rd of 2014.
He signed the original order.
The original order stating that she was properly served when she was not. And also on that document is the referee, who probably heard the case, you think?
That's right. Matthew Hagan and Mark H. Duthie, P number 3313, signed off on this court order
that says
on July 23rd, 2014, that says notice of hearing was given as required by law. Total BS.
Not. It was not.
It was not.
And so, we have the setup of the fraud by the first judge. We got the carrying out of the fraud on Danielle Austin by the second judge, and in cohort with a referee.
Referee Matthew Hagan.
So everything that plays out since that first day, that first hearing, is a nullity on its face, because they didn't follow the procedures that are written out for them to follow, not for Danielle to follow, but for them to follow.
Well, and that brings up a realistic question here. Why would it be a checkbox on the order following the preliminary hearing to indicate that notice of the hearing was given as required by law? And the answer to that is because everybody knows that without notice, there is no suit. Okay, so that's why there's a checkbox on this court order after the hearing to indicate that everybody was properly served as required by law, and knowing that they weren't. Okay, but it's okay, because they have that Michigan court rule created by the Michigan Supreme Court that is basically a gill net that traps these respondent parents in the jurisdiction despite the fact that due process was violated 7 ways to Sunday to get them there.
If they just simply show up, they are. It's like uninformed consent. You don't even know that you're giving consent because it's all written into the rules, and it's like a wink in the eye between these bar members, whether it's the judge, whether it's a court-appointed attorney, whether it's your own hired attorney, or whether it's the referee. Any of these people they know what's going on. The only person that's got the wool pulled over their head, and they're pulling it over their head, is the person.
There's one thing I'd like to touch on here, David, that we didn't bring up too clearly, and that in Daniel Austin's case, despite the fact that she wasn't properly served, despite the fact that these proceedings are proceeding against her entirely in fraud, I'd like to point out that the order after this hearing, item number 21, where it says, it is ordered, I mean, this is the context or the order of the court, the petition filed by CPS, the original petition, is not authorized. So not only did Daniel's children were taken and this petition was not authorized, she should have gotten her children back when the petition was not authorized on July 23rd. And the significance that folks need to understand is that when you're incurring the liability of stealing people's children, you need to maintain every effort to keep those children and prove why you should have them at that point because of the liability that it creates for the state. You know, right? They can't say, oh, you're right, we're sorry, we didn't have enough evidence, we didn't have enough
we
proof.
Committed fraud in the beginning, and so,
right.
These criminal behaviors, I'm sorry, but we just have to cover them up.
You know, instead of saying, hey, we were wrong, admitting liability, they have to, full force and effect, pursue this as though they're 1,000% right because of the liability. Hey, we snatched your kids. We can't just say, hey, we're sorry, we made a mistake. We got to keep going. You know, this is a steamroller system here. If we give an inch, you're going to sue the shit out of us.
And, Dani firing that second lawyer, the one that she paid $3,000 for, and they call him back in, and she fires him, like you said, 3 times, it's because they weren't finished with them yet.
Exactly.
They had him serve a purpose for them, and so they faxed this guy. They had this guy come in, and he sold her down the river with that recording, and we will be providing that recording if we haven't done it already. Because I tell you what, that's the one good thing about the alternative media. We here at RICO Busters are doing this for you. We're doing it with you. We're showing you how to do it yourself. And you've got to this is the freedom of the press coming right back to the way it was meant to be. Because the mainstream media does not cover this kind of stuff. And we're going to be laying it out as they are doing it. We're going to call it a fraud when it's a fraud. We're going to call it a crime when it's a crime. And we are dealing with a racketeering scheme that is in operation and hot on the trail to go after everybody, including you, if you don't watch out. We will see you in the next episode of RICO Busters. Thanks for joining us.